is absolutely clear, that when a challenge is made to a member of a panel, that member decides whether to recuse themselves, and the other members of the panel then choose their own course of action in the light of the decision made by that member. So there's nothing wrong with Justice Khampepe. Whether by accident or with knowledge of this, she made the right decision. She would have made the wrong decision if she said the decision is going to be made by the three, because what the law requires is that she must make her own decision, and that's what she did. Then Justice Khampepe should have recused herself. We say that with due respect, it's frankly absurd, because the facts are the following. Firstly, when the applicants objected to this arrangement, the chairperson had a hearing on whether this should be done. The undisputed evidence of Mr. Thalata in his answering affidavit is that this is what is done generally by commissions of inquiry. If I can give a bit of evidence, I know of that. Thirdly, the undisputed evidence of Mr. Thalata in his answering affidavit is that the same arrangement has been made with all of the parties, who are introducing witnesses to the commission. So there can be no suggestion that this decision shows any bias or against the applicants. This is what, and we'd like to introduce this witness as evidence. The mark of the applicant. It is a made the findings page 006. There was interference made in the Rodriguez case by the full. That's what actually happened, and that's what given rise to. What the commission now is to find out that it will be a travesty with less than 6 months to go. Two of the people who have if it will be a travesty of just blot on our history and on that justice delayed is just in this matter, justice has been sought to follow, including the two applicants. There is no substance. The institutional bias there's no of the context. We've made in the HRIU is that unit anyway, the calling of witnesses utterly without foundation, and fourth, the complaint that so for all of these reasons, whatever this is essential with the section institutionally biased, personally biased. The commission should be allowed to commission. If the commission, Mr. Zuma and Mr. Mbeki, and ask the court to say that what the commission process to be collapsed now challenge the appointment of they're in trouble. They're not in trouble, they're they can do is look after themselves.
To deal with that recusal application was brought to
That she decided.
She decided about why that was so.
The evidence that she decided members concurred. The decision was the decision of the three of them. It was indeed.
All right.
Really, it's her decision. It's her. It's not a Khapempe not to recuse her. Of the four justices of the Constitution.
Witnesses before. Does this also?
And would require special justification. Everybody else, you can lead your own witnesses. Two former presidents, but you may not do so. There are really two sorts of witnesses. Contacted, there are always, or very often, outside parties. To lead these witnesses ourselves. And the evidence in all such cases so far, this is
all the work that has happened on the facts, except that if there was a proper, but I understood you saying because that would be the travesty would be that you would distribute grounds advance.
Yes, of course, if this court decides that the review application should not have been dismissed, but or that Justice Rogers has decided. Bias that would be held by a reasonable, what was held, and was held by a reasonable, or would be held by a reasonable person.
Yes.
So double reasonableness test, yes.
Yes. Now, we know this is the opinion of the President, but what weight should we give to, that's the current President I'm referring to, President Ramaphosa. What weight should we give to his affidavit in the High Court where he says, had he been aware of Justice Khampepe's previous involvement, he would not have appointed her.
Ron, we don't know what the President knows. Which is without any factual foundation. This one knows on what basis he reached.
TRC,
yes,
and with the if
well,
he had known about that involvement.
Well, it sounds like he was misinformed about his. It wasn't informed that it had nothing to do with. I can't get it right. HRIU.
He wasn't informed of all the detail, been aware of that involvement. Appointed her.
Well, if he is, his position is with the NPA, you would have been entitled to make that decision. And I don't want to speculate. It was his opinion there, standing, and at least one is a ground for disqualification on the grounds.
The date period for the is after just that information obtained could impact on the
Impacted on, I accept that there can't be an iron curtain which slams down on the 1st of January. Before that, you can't consider.
impose a potential harm involvement.
Well, if decisions, if she had been produced of a letter written by prosecutions, they are going on both sides are going to be prosecuted. And
now, I know I might be asking at the Commission. It's not the chairperson. What's the likelihood of
it is highly speculative, Justice. Is from what she said. President Zuma ignores the fact that the issue were not matters that were pertinent or indeed at the, I didn't see any of this when I was there. She was only there for I have to say, on the basis of what she said, I know nothing about that.
Justice Khampepe's links?
Justice Turan, Davis was sitting, and that's
was involved in that and none of the two applicants tells us.
the way it happened, the way it arose. There was complaining about this and saying you can't object to anybody else. This is the time to do it, and the involvement with the HRIE or you got it. And they 7, and she says some parties may be preparing further disrupt proceedings in order to parties the earlier roles played by they then go through them and then the RC Commissioner, and in the following years. During this period, to the NPA, and that's what sparked all. But that's said she
by the applicants. It's thank you, Mr. Butlander. Rest of the hearing. Thanks.
There's parliamentary stuff.
Yes, yes, yes.
We have to speed. Oh, you're still going, yes.
Please switch your phones off. Court is about to sit.
Deputy Chief Justice, may I just draw heads of argument? I wouldn't like it. So the last sentence of paragraph 95.4.
6. Yeah, we will deal with that issue on the papers because
And of course, is
The
the
condemnation.
explanatory particular answers when that
this is the condemnation. To say.
well, so in fact, acceptance of that explanatory
Okay. So you want us to okay. No, thank you. Just here to, you've got the, thank you.
both of what
To
we've
do
asked.
what? Is
There
it not in your
is-
papers?
to deal with that court at all, because the court is seized with only the Section 47. And equally, after, I think they would still hold to it. There has been a denial affidavit, which simply put Justice Khampepe at any justice. As you know, the NPA has decided to that the people who have deciding to keep silent. When you consider the case as a whole, in actual fact, one of the things that we equally say, just to conclude, if there's ever been any time where the Alata group and the NPA candor, because the to be a truth-finding function. Other parties have done, because it doesn't have the fact. As that, question by it would be that this court needs to accept in instances and Advocate Semenya have filed.
I'm sorry to interrupt. This is attention to the paragraphs in our. There is the specific.
You're dealing with the silence submission.
Paragraph 13.1.
Loco, please come back. Ask for questions. You're going to get them.
Deputy Chief Justice, I'm not sure.
Justice Mato.
And because what is it that the NP?
Well, what the NPA is court to have regard to its right, during the silence business leader. As you will recall, for the recusal of the ask for the recusal, or do
Semenya SC.
No. If I can then take the court to particular. Yes, that is not what the NPA is saying there's been silence on by the NPA. For whatever reasons, did the chairperson provide Advocate Semenya alleged? Did the chairperson
The papers. Would those questions, the evidence leader and the chairperson interact, speak about, right?
Yes.
By one of the applicants. Pertinently asked the question. Allegations were made.
Just
It's not whether or not. It's whether the principal right, whether indeed there was or the application of Pasco and Evans rules. the conclusion that we must arrive at.
Necessitated the NPA saying, it's a simple yes or no. This is basically what
Maybe
the NPA says.
I don't, is what has been said. Applicant to say, we should make a determination.
Always been the submission of the NPA. The position of the NPA in this decision, then it's asking the court that when you make the decision, what it would mean that are alleged against the leader are true. There are issues
assist us in answering that question.
which 53, sorry, High Court, the NPA, when I say we, indicated why it was full record and obligations are. If the obligations, the NPA is not that these rights, because the NPA.
Can I please interrupt you?
Yes, Justice. Yes.
If we were to be a or prefer our order, if you are the NPA,
Just ask that the court have regard, and then you get to the review itself. NPA does not know.
That's why I didn't want.
if there is no rule position to make any ruling,
There's no record before you. I think let me just then finish the is abiding that those would have been facts, have enough before you on the that it would have been beneficial for all the other parties that have.
very much.
Thank you. And particular references that the group.
Thank you, Mr. Ntloko.
The reference to the record, it's page.
I think in writing.
Deputy Chief Justice, can we equally then be given that opportunity to just send its references? We will not say absolutely. This is where it's answered. This is the allegation. This is where it's answered. We are not going to make it. Say something else.
That's fine.
Thank
you.
Just references for both parties.
What our case is.
It's 10 minutes.
Yes, thanks.
Yeah.
On our case, are certain parts that are not clear. Which one of. Secondly, I agree with Justice Rogers' first page. You'll see that come here, it's still in terms of Rule 19. So that's, but if you go to page 2, covers what Justice Rogers was talking about, where one of upholding the appeal itself. We agree that it may Justice Rogers about Justice Dambuza. The point is made very clear in crucial and separate interpretation. Does the expression court point, I don't need to develop it. So the could mean any judge, but court. Because those two, just now by Mr. Badlander, that the issue of service is no longer pursuing. And then the fifth, we say the fifth, that the issue of service is no longer pursuing. And then the fifth, we say the fifth, was it the effect of decision, what is the effect of decision such as, was it the effect of decision, what is the effect of decision such as NP versus LP, Corruption Watch, Zuma versus Secretary for State as LP, Corruption Watch, Zuma versus Secretary for State Capture, and so on. I've made those points. That's the point about Mlambo JP, because if you're Mlambo JP and Menenga JP, if you are saying, as one of the defenses that has been offered here, a judge is a judge. You are saying a judge is a judge. You are saying both Mlambo JP are wrong, because both of those applies to but a judge is a judge means even if the distinction in one sex holding of office until and then we then deal with the notice of motion. We've dealt with that. The importance of that is that, remember, application, which Ms. Ntloko is quite well, if you don't have jurisdiction, we don't, what he called the purpose. I think something less loftier. In this section being independence and what have you, what is the other right. So which just so whether it's delayed or whatever, something that, as we said, is very quickly was urgent and the Zuma case. And on the basis that was said there. Now we say here of that because there are two former presidents. The issue about, I think it was that Justice but that's the point we're making. What's wrong with this picture? The point at which it is alleged into the stopping of the prosecution. Prosecutions may have stopped in 2003. considered that. There's a case called Dupree versus Tia. An AD case made it plain.
Last one.
Yes.
Yes, what is it?
Thing about HRIU that was,
Yeah.
I don't have time, I won't go to it, has 9.2, 9.3, 9.4. If he had known those things, affidavit of other TR, Ms. Suka and
No, but that's the point, isn't it?
Point about Justice Nook, who says what is reviewable is not
Thank you very much.
half a minute.
Thank you very much.
But I promise. And the point is this, and someone else said this. Outside of this abuse of court and so I'm going to take it.
Thank you.
Just go ahead.
The first point I want to deal with, my friend Mr. To the role of the presented, the commission must investigate, and the question when she was in the TRC long test. Of course, and Bennett emphasizes, you look at prior rules. And I want to 93 dash, you will see there that it's about it is dealt with from paragraph, and there it's set out at paragraph 23 of public prosecutions. The HR unit's mandate was to review TRC cases as a role in the HIU, including providing a member of the HI unit full stop. 011, paragraph 35 specifically, you never ever denied the office of the National Director, 269. Then you look at what Saldana and we have been asked to testify on. At 011, you will see that officer of your particular unit, you have any material in your possession, the above mentioned paragraphs of the terms of reference, such as state decisions relating to RC cases were taken. Nuka's statement (619), he says 13 with effect from 1 August 1990. Asked to do. These people were serving Section 5 says she is. She doesn't dispute 493, simply saying you advised, you played a role. This is a belated denial where amnesty was denied. .327 in relation to the PEPCO 3 as part of the of justice. A party, after full disclosure, is not allowed, not participant in the recusal of. So there was no adverse decision at all. In addition, in May, identifies the interest. The case of Mr. Mbeki was when is under 3 months. Incident was taken by the SCA. To allay the fears of any bias. Answering affidavit, those paragraphs, they're all argument. Just argument about why my learned friend referred to Dupree, but I'll mean that you still have to against the executive without hearing them. It question if that is correct. Question that the arrangement and the evidence, chief evidence lead. The parties objected. It resulted in all the chairperson did was endorsing all of that and finding Section 47, and that's my last point. Answer to the contextual reading the court, and we are really indebted to assist the court in making a proper determination course in the court's discretion.
Deputy Chief Justice authorized by my senior. He says, I think we've all appreciated justice and particularly your passion. We know you've written judgments about I think we all have also greatly valued and appreciated. On behalf of all of us, but I say that we service to the court and to the country. Very fruitful retirement. Thank you.
Advocate Badlander will come. Thank you very much for. We will also miss him. That said, this brings us to the end of today's proceedings, and the court adjourns. Judgment is reserved.